Hi everyone, it's Stuart Broom and welcome back to my YouTube channel on everything to do with data protection, privacy, security and stuff like that. Well, it would not have escaped your notice that today is Brexit Day, the 31st of January 2020, when the UK leaves the EU at 11 p.m. Technically, that's what's happening, although we will still be subject to EU rules until the end of the calendar year because we're in a transition period. But don't let that bother us. We have Brexited. So how are you feeling? Are you feeling happy? Are you celebrating? Going to be down the pub tonight, raising a glass? Or are you going to be commiserating? Are you going to be down the pub tonight, crying into a glass? Are you happy? Are you sad? Are you optimistic? Are you pessimistic? Well, it's going to be every shade of point of view about all of this today. But what I want to talk about is Brexit and data protection. I'll just canter through some of the technical issues that apply to Brexit and the transition period. So there are two key documents. There is a Withdrawal Agreement, which is a treaty between the EU and the UK, and there's a political declaration. Now, the Withdrawal Agreement maintains, in effect, EU law in the UK for the transition period. So up until the end of the calendar year, EU law on data protection is applying in the UK, and we recognise that to be the law within the GDPR. The political agreement contains an expression of the parties' will, their intent, their frame of mind that will govern the conduct of the negotiations that will continue over the rest of the year. Now, the first point is that the EU and the UK have expressed the political will to maintain high levels of protection for personal data. So that's fantastic. We know what the overall ambition is. And what's also going to happen is that the EU is going to assess the quality of the UK's data protection regime. Vice versa, the UK will assess the quality of Europe's data protection regime, with the intent that both parties will say that the other party's laws are adequate. What that means is, currently Europe has a power, a legal right, to declare the data protection laws of countries outside of Europe to be adequate or non-adequate. And if they declare the law of a country outside Europe to be adequate, then personal data can flow from Europe to that other country without any significant legal impediments. However, if Europe doesn't declare the other country to be adequate, or if it was to declare it was not adequate, then there are a variety of legal hurdles that have to be overcome to enable personal information to flow from Europe to that other country. So that's one of the big exercises that the UK and Europe will undertake over this year. They will look at each other's laws and hopefully they will come to a conclusion that the laws are adequate and therefore there is no need to have any legal barriers in the way to information flows between these two countries. But it's also worth remembering that Europe successfully trades with countries such as America, China, many other countries that have not yet been declared adequate from a European law perspective. What that means is that global trade, global data flows are happening very successfully without this sort of badge of adequacy being in place. So if we cast forward and we end the transition agreement without Europe declaring the UK to be adequate, UK declaring Europe to be adequate, we would hope and expect that data flows will continue because that's been the pattern for global trade and global relationships, regardless of Brexit. So for situations where there isn't a badge of adequacy for countries outside Europe, the European legal regime has a number of workarounds that enable personal data to continue to flow. And it's worth remembering that the overwhelming majority of countries outside of the EU do not have a badge of adequacy. Or in other words, a badge of adequacy is the exception, not the norm. So what are these workarounds? Well, for instance, if a person was to consent and give permission to the flow of their information from Europe, that enables it to take place. If the flow is necessary, for example, to fulfill a contract, information can continue to flow. And then there are a number of legal mechanisms that can be put in place by data importers and data exporters to enable the continuation of data flows. So, for example, they can put in place standard contractual agreements that are perceived to create a private law adequacy arrangement, if you like, in contract. Or the parties could put in place a set of corporate rules, known as binding corporate rules, where the plan is to share personal data within a group of companies or a group of organisations. And for information flowing from Europe to the United States, there's a mechanism called the Privacy Shield, which currently enables these data flows to happen. So if we get to the end of the transition period and Europe doesn't declare the UK's data protection legal regime to be adequate, doesn't matter, right? Because there's all these workarounds. Well, in a purely technical legal sense, you could make that argument that it doesn't ultimately matter. But if you take a bigger view of this, then it does matter. So the adequacy idea, the idea that a regime has gone through a variety of assessments, enables people to feel confident that laws are of good quality, whereas a failure to get an adequacy decision might undermine confidence and create suspicion about what's going on in a particular country. We don't want to create false confidence at all, but real confidence is important, particularly on the online environment and e-commerce and the web and things like that. So I think confidence is important. Also, if we have equivalent legal regimes, so we don't need to employ all of these workarounds, that removes a drag on efficiency in the economy. It just makes life a lot easier, and it removes costs and administrative burdens. So if you think about the idea of resource allocation for data protection, organisations don't have unlimited budgets to spend on data protection. That's a fact of life. So there's always constraints and limitations. And therefore, you would want the cash and the resources to be expended on the most important matters, and not having to spend money on creating legal contracts will enable money and resources to be spent on things such as better quality security, faster reaction times for responding to data subject rights and things like that. Now, when Europe comes to look at the adequacy of a foreign country, it looks at more than just the legislative framework, the acts of parliaments, the statutes, into the culture of the country, into the extent to which laws are properly enforced, the extent to which the professional environment in the country respects issues that are close to or akin to data protection. So it's looking at a holistic assessment of adequacy rather than a purely legislative assessment. So if we break that down a bit or truncate it, then a country that upholds the rule of law, a democracy, a country with a track record in respects for fundamental rights and freedoms, should be in a good position to gain an adequacy decision if it has in place a data protection legal framework that is addressing the core components or the key requirements of the European regime. So if you look at it like that, the UK must be in a really good position, right? We've got the Data Protection Act 2018, and prior to that, the Data Protection Act 1998, and prior to that, the Data Protection Act 1984. Obviously, up until the moment of Brexit, we are part of the EU and therefore following the same regime. The current legislation, the Data Protection Act 2018, bakes in the GDPR. We have got statutory regulators that are concerned with data protection issues. So we've got the Information Commissioner's Office, the specific regulator for the Data Protection Act. But we've also got other regulators with data protection focused duties, such as the Surveillance Camera Commissioner. We've got Ofcom. And if we look at wider sectoral regulators, such as the Financial Conduct Authority, Ofgem, they look at data protection issues too. If we go further than that into the culture of our society, for instance, in the professions, the legal profession, the medical profession, there are very strong obligations around client confidentiality. If you look at the question of the rule of law and how that is adhered to, we have an incredibly strong judiciary that's independent from government. We are a democracy, and the judiciary regularly holds government and the state to account. There is a significant track record of pro-data protection judgments and pro-privacy judgments. So an adequacy decision for the UK is a slam dunk, right? It must be. And to coin a phrase that we've heard about over the past 3 years of Brexit, we're starting from a position of very, very close alignment. Look, I've not got a crystal ball. My guess is as good as yours on what will happen. But there are concerns being expressed about the overall environment in the UK that could potentially weaken the case for adequacy. And the main area that is being pointed to is about state surveillance. And the UK, of course, has experienced a lot of exposure of state surveillance challenges, most recently in the context of the Edward Snowden disclosures. That's led to a lot of litigation. And if we return to the idea of automated facial recognition that I've been discussing recently, there's a lot of concern being expressed about the impact of that on civil liberties, data protection, related matters such as privacy. So some commentators are saying that our state surveillance environment weakens our arguments on the issue of adequacy. But of course, the question of adequacy, I believe, is more than just a holistic legal assessment. It's also a political matter. And at the end of the day, politics can find its way through many problems. But conversely, politics can create problems. So all eyes are going to be on the agenda and the activities of the new government, the new Conservative government. And here there are some really interesting things to look at, specifically the Conservative Party Manifesto and also the recent Queen's speech. Now, manifestos are, I believe, written to give as much wiggle room to politicians as possible. So you can select from the manifesto to support many different arguments. Now, one of the things I was looking at in the Conservative Manifesto is the commitment to improving worker rights. And of course, one of the right issues that workers are concerned with is a data protection right. So you think about surveillance in the workplace, or think about the workplace as potentially a private place. Then if we're going to increase worker rights, at the very least, would that not mean we should maintain data protection rights at least the current level, which are equivalent to current European rights? So there's that kind of argument. You could move the Conservative Manifesto in that direction if you wanted to. But there is actually a commitment to look at the human rights agenda inside the UK. And again, the manifesto is pointing to improving the human rights environment. When you ask the question, what does improvement look like? Well, it depends on whose perspective you take. But in this narrative, the Conservatives are pointing to the need to improve the human rights regime so that it's proportionate also to key needs of law enforcement. And that is a segue back, if you like, to some of the surveillance kind of issues that commentators are pointing to as being a potential problem area for the UK. And one of the flagship announcements in the Queen's speech was the launch of a Constitution, Democracy and Rights Commission to examine our overall rights agenda. Now, where that's going to go, I don't know. As I said, it has lots of wiggle room within it. It doesn't mean necessarily a weakening of rights. It could mean a strengthening of rights. Anything is possible, and I think politicians want to keep their options open, so we could be potentially realistic about that idea. But what we can be sure about is that it focuses attention on the question, what will the government do? Not just now, but when we are through the transition period. So we need to watch the work of that commission closely, or at least we can be sure that those who will perform the assessment of the UK's adequacy will be looking at the output of that commission's work. So how do you feel? Do you feel optimistic? Do you feel pessimistic? Do you think we will get an adequacy decision? Do you think we deserve one? Where do you stand? Look, I've no idea what's going to happen, either in the context of the legislative developments that the government may move forward, or the outcome of the assessment that Europe may perform. It's certainly conceivable that we may end the process without an adequacy decision. But I remain really optimistic. I do, thinking about this. I think we've crossed the Rubicon on data protection. I really do. I think that no matter what the government may do, no matter what the Commission may say, I think us as citizens, us as people, are only going to be more aware of our data protection rights, more concerned about them, more assertive about them as time passes. I think they will become more precious to us as time passes. But also that the users and controllers of data processing and personal data will advance in the same direction as the will of the citizen. And we're seeing so many green shoots that should give us encouragement that data protection will live and thrive past the narrow legislative regulatory regime and the issues that we're just debating now. So, I hope you liked the video. Thanks for watching. If you did like it, can you give a thumbs up? Press the bell button if you'd like to be updated on new content. And whatever it is, be friendly, love one another, and let's live in peace.